Thank you for that introduction. I really appreciate it. And I also appreciate everyone for logging on and listening to this program as well. So I hope that you get some questions that you might have in the back of your mind answered, as well as feel free to contact me if you have a more specific question. And there will be time for questions at the end. So as we get into this program, obviously from the title, we're looking at federal criminal charges as they apply to pharmacists, and also the relationship that charge may have with the Board of Pharmacy action. In addition, we're also going to look at pharmacy malpractice, but we're going to spend a very brief amount of time on that issue, and that's a whole different matter in and of itself. We're also going to differentiate between which agency will investigate a DEA or a controlled substance matter. Is it DEA? Is it the state police? And is it the local police? We're going to look at the Board of Pharmacy. Now, again, each Board of Pharmacy is run by their particular state laws, and they have their own state regulations. So anything that is said here, you want to apply that to your own state regulations to be more specific. And then we're also going to look at the standard of proof that the government has in a criminal matter. Generally speaking, the government has to prove their case beyond a reasonable doubt for each of the elements of the crime. So if the easiest example would be a burglary. If it's done at night, the taking and the breaking in. So if it wasn't done at night, it's not a burglary. So if a person is charged with burglary, they're probably going to be found innocent or not guilty for that crime of burglary, and they should probably be better off being charged with a different crime. And we'll take a look at that as well as it applies to pharmacy, though. So the three areas of law that we're going to look at in this program, the main reason we're looking at these three areas is that they are all interconnected. And I want to leave you with that message that if you have a malpractice case, there could be a broken crime violated which led up to that malpractice. And then the Board of Pharmacy may get involved as well, which is the administrative law portion. So let's take a look at civil litigation. That's really malpractice as we know it. And that's the award of damages. You have a plaintiff and a defendant. It's time consuming. It can go on for several years. A pharmacy or pharmacist or a hospital, nursing home can spend a tremendous amount of time collecting documents, providing deposition testimony, trial testimony, coming up with evidence. Stressful. As I mentioned, it could go on for several years. All of that time, you're being asked for more information, phones ringing, not pertaining to your business, but pertaining to this litigation. And obviously, it's expensive to defend. You're having to pay a lawyer. Some can charge as much as $400 or $500 an hour. Tremendous amount of hours go into litigation if it goes to trial. Therefore, if I don't mention it later, I want to mention it here. It's a good idea for each pharmacist to have their own malpractice insurance. It's relatively inexpensive, close to $200, I think the going rate is. You get not only malpractice insurance because your employer may or may not cover you, and again, that's a whole different subject, but if you violate a company policy, the hospital or pharmacy may look at you and say that they're not going to cover you in that litigation. I find that some pharmacies don't have malpractice insurance. So you could be working for someone that ultimately doesn't have insurance. And then lastly, some malpractice insurance coverage, and you have to find out if the one you're interested or have has Board of Pharmacy complaint violation coverage, where they're going to pay for an attorney to represent you in front of the Board of Pharmacy. Criminal law. So the government is seeking to take somebody's liberty. The ultimate is to put that person in jail. So it's the government versus the person. The government, as we mentioned, must prove each element of the statute has been violated, or the person may be set free or the charge is dropped. Administrative law, fancy name for Board of Pharmacy law. Their mission is to protect the health and welfare of the public. They're not in place to save people money, patients money at the pharmacy. They're not put in place to create convenience for the patient. They're there to help the public stay healthy and to protect them as well. Obviously, a license is considered a privilege. I think we all know that. It is similar to a driver's license. It can be taken away, revocated, or suspended. Rules are more relaxed in favor of the state. Unfortunately, unlike the two previous areas of law, criminal law and civil law, they have statute of limitations. After a couple years, whatever the infraction may be, the government or a person, individual in a civil matter may not be able to bring that case further because of the statute of limitations has ran. Administrative law goes on for a long, long time. I have seen issues just work their way through the process that have taken several years. You can find that it could take 5 years from the date of the occurrence to the date that the Board of Pharmacy signs off on the penalty. So there's really no statute of limitations as it comes to administrative law. There's no sharing of documents required as there is in civil and criminal law prior to a hearing. So yeah, the rules are more relaxed in favor of the state. The Board of Pharmacy decisions can be appealed to the court system. And what I mean by that is if you have a hearing, that hearing judge offers a recommendation to the board. The board accepts that recommendation. It becomes a final judgment against you, or your license, I should say. If you want to appeal that, you can appeal that to the court system. In my opinion, it's difficult. The Board of Pharmacy is in a better place to understand the regulations and the reasons for those regulations. And secondly, you've had due process. Due process means you've had that opportunity to be heard. You've had a hearing. A hearing examiner has made a judgment on the facts. So that state court system that may be asked to intervene or overturn that Board of Pharmacy decision, in my opinion, is one step behind in not wanting to do that and not wanting to basically get involved unless the decision appears to be arbitrary and capricious. What is meant by that is that there's really no relationship. A pharmacist steals a pack of gum and they have their license suspended. It's arbitrary or it's capricious, that penalty. It doesn't fit and it doesn't make sense. Then the court will step in, and obviously that would be a great reason to. The Board of Pharmacy could bring an action for stealing a pack of gum. One is if the complaint got there through the police or the store, got to the Board of Pharmacy. And secondly, under a moral turpitude regulation, the board could bring that action. And I've actually had one case where I believe it was a nurse had stolen a lamp from a small department store and had been arrested for that, and they had put her license on probation because of moral turpitude. So as we mentioned, there's a connection. And I've kind of given you a couple examples. If someone commits even a minor crime, they are in trouble criminally and have to deal with the penalties and the fines and the issues involved in the criminal matter. But also the Board of Pharmacy may be handed that information through agencies that are connected. And you may find that a Board of Pharmacy action can arise out of a matter that seems completely unrelated, especially when a person is terminated. I have nursing home nurses that when they're terminated for a reason, they often will report that to the Board of Nursing. In that case, then the Board of Nursing will take action. And likewise, in a pharmacy setting, if a pharmacy has terminated, or a hospital, for example, they have a human resource department and the termination goes through the human resource. There's a good chance that the Human Resource Department can send that information to the Board of Pharmacy. They may feel that there's an obligation to do that based on the circumstances. So working with a client, it's really important to look at the three areas of law and see how they're going to affect each other. So I have a case now where the pharmacy has been cited for for filling controlled substance for patients out of state. Multiple states, and they're relatively far away from where this pharmacy is. So the person may have to travel into this state for 1.5 to 2 hours. The Board of Pharmacy has taken action. Now, what other area of law to consider? That other area of law is criminal law, because we don't want to say anything that will be an admission to a crime in an effort to move forward with the disciplinary action and get over that issue. So a pharmacist might think, if I admit to filling these prescriptions in a way that I shouldn't have, that they weren't for a legitimate medical purpose or not within the scope of the physician's practice, that they admit to it, they may have to pay a fine and move on. But they can then turn that information over to the Attorney General's office or the DEA and bring a criminal matter. If someone got hurt in the process, which prompted all this, you could be looking at a disciplinary action and a malpractice case because the person was injured, and a criminal matter as well. So let's take a look at a case study here. A pharmacist administers a lethal dose of a narcotic. Now you got a wrongful death action, a malpractice, a civil case. You've got a plaintiff, the surviving family, and you would be the defendant, and the pharmacy or hospital could be the defendant as well. Now, this is where it really gets scary, that, and you won't often see this, and quite frankly, but it's a good example of how things can really go wrong. In Pennsylvania, there's a manslaughter statute, and we can read that on the slide as it goes. But I want to stress the third line from the bottom, starting at comma or. The doing of a lawful act in a reckless or grossly negligent manner, he causes the death of another person. Okay? So the top half is somebody who's acting recklessly and grossly reckless. Maybe someone, vehicular manslaughter is someone driving so recklessly and they injure or kill somebody rather. In this case, a pharmacist could be charged here with a wrongful death because they're acting in a lawful manner, but recklessly and grossly. And one could make the contention that if a pharmacist is dispensing narcotic medication that kills somebody because of, say, respiratory depression, and the quantities are high, and it's early filling, they're paying cash, and they're paying on insurance, and it keeps going on, they could be charged with this state criminal statute, okay? And it depends on the county prosecutor whether or not to bring a charge here. Now, moving over to a federal statute, and I don't think that you're going to see this issue on a federal level, but it's worthwhile to point out, just like the Pennsylvania state statute, the federal government has a similar statute, and we'll go down into the red, where it says, while acting without due caution or circumspection in a lawful action which might produce death. Okay? Now, let's say these are, obviously they're controlled substances. It falls under the DEA. So they may have jurisdiction, the federal government, to bring this type of manslaughter statute upon a pharmacist. Now, finally, the administrative law. And after what we just talked about, seems like piling on for the pharmacist, but this needs to be considered that if someone passed away and a pharmacy issue is involved, the board will get that, or should get that, and you can likely see a Board of Pharmacy complaint, action, notice of violation of Board of Pharmacy regulations. So, what can the Board of Pharmacy do to a licensee, their license to practice pharmacy? They can take no action at all. They can look at the matter and say that this was strictly an accident. Under the circumstances, a reasonable pharmacist would have done similar. And they can send you a letter that says, we've looked into this matter and we're going to take no further action, but if another occurrence of any type comes up, we will combine the two issues and look at your license to practice pharmacy. closely. You can get a letter of reprimand. Now we're getting into disciplinary actions. And in my mind, there's two types of reprimand that I've seen. One is a reprimand that says, we believe that something's happened, but we're not going to take further action. That's not a disciplinary action. I've seen letters of reprimand that say, we're going to publicly reprimand you and take a disciplinary action, impose a $50 fine, and require you to do X amount of continuing education credits upon over your normal amount in the area of patient safety. Now we're moving into disciplinary actions. In Pennsylvania, that does not go away, and that's searchable, or you can request that through the Board of Pharmacy Prothonotari's office. That's the record-keeping department of the state for the health agencies, and that then becomes public. We can move into license suspension. So the Board of Pharmacy can suspend your license, and they can offer what's called a stay. Better way of saying that is hold on the suspension. So the document can read, this pharmacist license is being suspended for 1 year, stayed for probation. And what that means is that the suspension is on hold for a year. The pharmacist is actually on probation. If anything happens, then that suspension will automatically be instituted. And you won't have the due process. There won't be a hearing. There won't be any questions asked because it's already been in place, that due process previously. Then there's straight suspension. They can suspend a license for 1, 2, 3, 4, 5, 7 years. It doesn't matter. And then there's license revocation, which is basically requiring a licensee pharmacist to turn in their license and they cannot get it back. And I haven't seen this very often. I've seen it proposed, and this is obviously, the nuclear option, and this is the option when I'm given this option. You've got nothing to lose other than to fight it. And that is that if your license is revoked, then the licensee can never practice again in that state. Now, there's a lot of collateral consequences with suspension, revocation, even reprimand. Collateral consequences are, does the pharmacist have other pharmacy licenses in other states? Is the pharmacist a licensee of any other agency? For example, are they a realtor? I've seen and represented land surveyors and architects, and they may have dual licenses. Engineers and surveyors have dual licenses. So the collateral consequence would be that if you have a disciplinary action in Pennsylvania, then you're probably going to have to report that on your license for another state. Then you're going to have that same problem, have to hire a lawyer and work through that issue in that other state. And if you have many different states, then you got to go through that analysis for each state. And as I tell people, no matter what it is, report it, because you don't want to be accused of acquiring a license renewal through fraud by not reporting another state's disciplinary action. Then you also have to defend the other state's disciplinary action on top of that, which you may find that the other state may or may not add to it. Okay. So what type of complaints are there with the Board of Pharmacy? Really anything that's reported to them, the Board of Pharmacy will investigate. And they may not spend a lot of time on it if it's, I'm reporting that this person's tie color I didn't like. Okay. They will investigate that because they want to make sure that they're not missing something. Okay. Obviously, they're going to spend more time on the things listed on the slide. Medication errors, as I mentioned, maybe an angry patient, employer reporting, we talked about that, of incompetency, drug diversion, termination, and such. CE credits, if you don't have CE credits, that's a Board of Pharmacy action. It's really not going to be a complaint. You're just going to get a letter, and there's nothing I can do to help you. I don't take those cases because it is what it is. And unfortunately, you're probably going to look at a fine. There will be a disciplinary action, and you will have to report that to whatever other states you're licensed in. A state agency can also file a complaint. For example, if the state police, attorney general's office, local police have a diversion issue, they can report it to the Board of Pharmacy as well. Mental competency is also an area, not necessarily a complaint, but an area that the Board of Pharmacy will look into. So the Attorney General is often the department that gathers information for the Board of Pharmacy. So the Board of Pharmacy does not have their own per se investigators in many states. And many states they do. But for example, in Pennsylvania, that investigator falls under a different department, which is the Attorney General's office. Ultimately, the Board of Pharmacy goes up to the Attorney General's office as well. So one way that an investigator will contact a pharmacist if there is a complaint, especially if they're out of state, they can mail them a questionnaire and ask them to fill it out. 30 questions as to what happened. Often an investigator can't cross state lines, mainly due to financial reasons. So therefore, if it's out of state, they can mail a questionnaire. They can also knock on the person's door if they are in state. And I have seen them come to the pharmacist's house to ask them questions. Also, they can telephone them and just generally send them a letter and ask them to respond either by telephone. Investigators really want to interview the person in person, and that's when you want to contact a competent attorney to go with you. The investigators are fine with that. They work with attorneys all the time, and they know that the attorney will help streamline the process as well. So what happens is that the investigator will collect the information. They're going to interview you. They're going to interview the facility. They're going to interview anyone else that has a license. And I've heard that the investigator can speak to anybody that has a professional license. If a spouse is an engineer and they have an engineering license, then that investigator can speak to the spouse. Now, that investigator doesn't have jurisdiction if the spouse doesn't have a professional license with that state. Okay? So what happens is they collect all the information. They don't make judgment. They send that file to the state, and the attorneys sit around and decide, is this a case we want to bring? Is this a case we really want to bring very quickly and make it urgent? Or do we want to close the case? As we mentioned earlier, a person can receive a letter that says, yes, we think that tie was offensive, and we think that you violated the moral turpitude statute, but we're not going to take further action. Case closed, no disciplinary action, nothing that goes against your license. You don't have to report it to other states. They could close the case with a reprimand and suggest that you pay a fine to settle this or add CE credits. Or they could move forward with a formal administrative action. And if they do that, they can offer a consent agreement. The consent agreement will close the case, but there will be some admission of wrongdoing. Okay, so I did improperly fill that prescription. I got the labels backwards. I violated the pharmacy code because I did not competently fill that prescription. You sign that document, now it becomes public record. Now you have to report it to other states where you might be licensed, but the case is then closed. Okay? If you do not agree with that consent agreement and you don't want to agree to the terms of it or make that admission, okay, that you violated that regulation, the state will then send that to have a disciplinary hearing if you choose. If you don't want a disciplinary hearing and you don't respond, they will immediately send it to the Board of Pharmacy for direct action. So at that point, you will send it, you'll want to answer the complaint by the state and request a hearing. Now, let's say that consent agreement, you're fine with admitting to the wrongdoing. You made the error. You're okay with that. But you feel that the suspension is not warranted. Probation would be fine. A monetary fine, CE credits would be okay. but you feel that a suspension would be going overboard, you'd lose your income, you'd lose your job, and the chance of finding another job in a year after being suspended would greatly impact your chances of being reemployed. Therefore, you go for that administrative hearing. At that point, you're not looking to block administrative action at the hearing. You're not fighting the charge. You're pretty much going to succumb to the facts. And the state, in this case, will meet a very low burden of showing that a violation of the pharmacy regulation had occurred. And you're okay with that. But you're looking to mitigate. And what you're trying to do is mitigate the penalty and try and get the least penalty. And I've actually, under certain circumstances, requested no further disciplinary action. That because of the criminal aspect penalty, the civil litigation, that this pharmacist does not need a greater penalty put upon them through the Board of Pharmacy, that they understand the severity. It will be a deterrent and it will show others not to do what they did. On the flip side, the state's attorney may ask for that 1-year suspension. And I'll leave you with this message, that if the administrative hearing examiner finds that the pharmacist furthered a crime through the practice of pharmacy, all cards are on the table, and he or she can hand you any well, first of all, they can hand you any penalty no matter what. Brace yourself for a very severe penalty, is all I'm saying. So I would not really want to go to a mitigation hearing unless I absolutely had to, if the infraction involved your pharmacy license furthering a crime. For example, committing insurance fraud while practicing pharmacy. So again, we've talked about what a consent agreement does. It's nice because it ends the matter relatively quickly. The pharmacist has to agree to the penalty and to the admission that they did something wrong. And as it stated on the slide, further time-consuming action is now resolved, and disciplinary action, which can take months and even years, can end. So we've talked about that, where it's the state versus you in an administrative hearing. And the pharmacist is called a respondent. Think of it this way, as you are responding to the petitioner. The petitioner has filed a petition stating the facts that a violation has occurred. Now you're responding to that, so that's why they would call you a respondent. You're not a defendant, not a plaintiff. At a hearing, that's obviously your day in court. You can present witnesses. It gets to be expensive if they are expert witnesses. However, family members, patients, friends can all be witnesses. They can be witnesses to your character. They can be witnesses to the events that took place. Evidence is presented. There's an opening and closing argument. There's a stenographer. It looks just like a court case. It essentially is a court case. Now you decide whether or not you want to speak. I don't think I've had an issue that went to a hearing where the respondent pharmacist didn't speak on their own behalf. Because this is mitigation, it's almost essential for the hearing examiner to hear the perspective directly from the respondent pharmacist. So that administrative judge is really not likely to be a pharmacist. They're more likely to be an attorney, hearing many different cases and hearing cases all across the spectrum of professional licensing. These cases mainly involve suspension and revocation. For probation, it's just a good idea probably to settle the case, unless you absolutely didn't do what you're being accused of doing. So we want to lessen the time frame of a suspension, bring it down to a probation, have it down to a reprimand with no disciplinary action. Or we've been offered revocation, and I'm seeing more and more offers of revocation in consent agreements, which from my perspective, I can't recommend the respondent pharmacist to agree to, because they're never going to work again as a pharmacist, so you might as well go to the hearing. And I'm not sure, how reasonable it is for the state to offer such a thing. Tell the pharmacist to mail in their license. It's a summary. It's a summary revocation, where the summary means that there's not been a hearing on the matter. Now, the administrative hearing examiner will issue in several months after the hearing a non-binding opinion and recommendation. That information will be taken to the Board of Pharmacy. The Board of Pharmacy will vote. Do we accept the administrative hearing examiner's recommendation, or do we open up this case and look at it ourselves? That portion of the Board of Pharmacy meeting is in private. It's not open to the public. Much of the Board of Pharmacy meeting is open to the public. However, review of administrative hearings is not. And as we talked about, they offer a non-binding opinion. When the Board of Pharmacy finally signs that opinion and approves it, it could be one of their own, it could be the administrative judges, then the matter is closed. And then you have to read that to figure out what you have to do. Pay the fine by a certain date, do the CE credits, and I hate saying it, but turn in the license at a certain time, whatever it might be. Now, this next slide is timing, because a lot of people want to know from the very beginning, how long is this going to take? And we talked about civil litigation earlier, where it can take years. And it can take years here. And we actually add this up and it comes to 14 months. And I think that that's conservative, quite frankly. So from the date that an event occurs, the investigation could take a month. And I believe they have up to 6 months to send that file to the Attorney General's office for review. So that could really be 1 to 6 months. Then by the time they review it is probably another 2 to 4 months at the legal office of the Attorney General. Which way do they want to go? Now, if a hearing is requested by the licensee, then that's between 1 and 2 months for it to be scheduled. And that's where we see the hearing date as well. The results from the hearing can take 6 months after the hearing to find out what happened. Then the Board of Pharmacy has to meet, and they only meet once a month. So if they miss that one cutoff, then you could be looking at another one. Or if the agenda is really full, you can be looking at 3 months. By the time they get a letter out to the respondent and their attorney, you're looking at well over 1 year, especially from the date of occurrence. So we've talked about license suspension, the need to reopen the matter by applying and appearing in front of the Board of Pharmacy. You don't often get that right unless your license has been suspended and now you're trying to get your license back. They may require you to appear in front of the Board of Pharmacy a year later. Now, I always recommend my clients have your CE credits up to date, a letter of good character, whatever the deficiency was, proof that you've overcome it. A criminal background check that shows there's been no problem since your license has been suspended. Even if you have a witness to come with you, if you're required to appear in front of the board to get your license back after suspension, is a good idea. This is an important point. If your license is then suspended for 1 year, in the previous slide we talked about, it would take you 14 months to get through the process, and then add 12 months to that. Now you're looking to get your license reinstated. I've seen it take up to a year to go through those 2 previous bullet points, to get scheduled in front of the Board of Pharmacy, to get all the paperwork together, to make sure that the issue that you were accused of is completely cleared. And I've seen that take up to another year after that person was eligible to appear in front of the full board for license reactivation. So let's go through a couple cases real quickly. A pharmacist answers the question on a license renewal stating that he obtained 30 CE credits in the last 2 years. They just, online, they check it off, they pay the fee, and send it in. Now, through a CE audit, the Board of Pharmacy randomly sends notice to the licensee to request copies of those 30 CE credits for the previous 2 years, which is the board requirement. The respondent had many certificates of training. Now, this is a real-life case. They had no CE credits. So, $100 per credit times 30 credits, they owed $3,000. They get a disciplinary action. There's no hearing involved in these types of matters. Now, with the CE monitoring program, it's going to become easier for boards of pharmacy to do these audits. It's basically data mining now, and they're not going to have to do random audits. The random audits might show that many pharmacists are compliant. Well, with the new CE reporting electronically, they can just target the folks that didn't meet the requirement. So we may see more of this because it's easier for boards of pharmacy to find which pharmacists are violating. And it's, I would imagine, more cost effective as well to do it this way. Now, let's say if a pharmacist then sends a letter of excuse. I've got a lot of training at my work. We do training on a monthly basis, but it's not ACPE approved. The Attorney General's office will still come down with that licensure deficiency. They will also add a charge of renewing a license through fraud because the pharmacist checked that off. Another issue that I see often, and please take this to heart if it pertains to your situation, that when you go to renew, we've talked about it earlier, if you've had an action in one state, that you report it when you renew your license, or if the state has, a lot of states have a 20 or 30 day reporting from the time of the disciplinary action, and not to wait until the renewal if your state requires a 20-day prompt notice, or don't make the mistake of, I didn't know that the $50 fine was a disciplinary action. I marked off on my renewal, no disciplinary action, sent in my money, and now you've got a issue as stated there, which is a violation for renewing a license through fraud. The state agencies are using a healthcare data bank. So when one state has a disciplinary action, they report it to a national data bank, and the other states will pull that information and they will know it very quickly. So my suggestion, again, I don't mean to belabor it, but I have seen it with many pharmacists, is report it. When you reciprocate your license, report the disciplinary action, even if it's minor, and a long time ago as well. So to just briefly recap, the Attorney General's office will either offer a consent agreement, and if those terms are agreed upon by the respondent pharmacist, then the case is relatively closed upon the Board of Pharmacy signing off finally. Or if those terms are not agreeable by either party, the Attorney General or the respondent pharmacist, then an administrative hearing should take place. That administrative hearing has to be requested in the proper format, or it would be considered a default, and the Attorney General's office would skip the hearing process. Now, to complete this example, the person that contacted me had no ACPE credits, so therefore they were fined $100 per credit, or $3,000 total. Their name would appear in the Board of Pharmacy newsletter that used to be mailed to pharmacists, but now many of them have an online email newsletter, or their name has disciplinary action when an employer or anyone goes to search their license. In Pennsylvania, that disciplinary action associated with their license upon search is not removable. In other states, after a certain period of time, for example, 5 years, the Board of Pharmacy will take their disciplinary action off of their name when they search that license. But in Pennsylvania, for one, it stays on forever. Now, let's move to the second case, and that is a drug diversion or an addiction case. This is a real case as well, where the employer notices missing medication. How do they notice missing medication? It's reported by an employee when the pharmacist is on duty. There's some discrepancy in the books. When the pharmacist is not on duty, there's no discrepancy. The pharmacist goes on vacation and the books are fine, and the pharmacist comes back from vacation and the books have been altered as well. So we're involving controlled substances. These are not non-controls. You would expect these to be resolved in a short period of time. But unfortunately, many pharmacists that are involved in these cases are set back at how long it's taken the employer to discover the problem. And it's kind of an odd situation at that point, because the employee pharmacist is saying, why didn't they catch me sooner? Well, the pharmacist had done a pretty good job covering their tracks. And now the pharmacists wish that they had been caught much sooner, because they're looking at 8, 10, 12 months of diversion, as opposed to, in their mind, I wish they would have caught me in 2 weeks. And it really, in real life, doesn't work that way. So the Board of Pharmacy will be contacted, as well as maybe law enforcement. Now, the Board of Pharmacy, they're going to look at this pharmacist as whether or not they're fit to practice. Do they have an active addiction where they need treatment and they should not be in the pharmacy? The Board of Pharmacy may, they don't always, but they may transfer the case over to the criminal division. And the criminal division may look at this case to see if any laws had been broken. And finally, the Board of Pharmacy may look at this also to determine whether any Board of Pharmacy regulations have been broken. And we've talked about moral turpitude earlier, but this kind of goes a step beyond that. And as we just mentioned, the employer notices that when one pharmacist is on, there's prescriptions that are being backed out. There are prescriptions being overridden at the point of sale system, and it's never being done on the other pharmacist's scheduled time. Therefore, the employer may set up a videotape. And what they want to do is, first of all, no sound. In some states, that's inadmissible, and it may actually even be illegal. So they can get enough evidence just by setting up a video camera and taking a look at what the pharmacist is doing while they're on their shift. Now, the employer will likely do two things. One is request a drug urine test immediately. And second of all, they may pull the person into their loss prevention office and try to get a written statement. Now, if we went further with this program, we could discuss what happens within that loss prevention meeting, but we're not going to touch upon that now. But I do want to make you aware that the employer at some point will bring you into the office with witnesses and try to get a statement. The next thing is the employer may suggest, or I may suggest, that you call your Board of Pharmacy and get into a voluntary recovery program, assuming your state has one. And again, I'm modeling this talk around Pennsylvania. We have the VRP program, or the Voluntary Recovery Program. That is part of a state agency. And I point that out to you because they also, in Pennsylvania, work with SARF, which is a peer assistance program. And that is not a state agency. They are funded by the Board of Pharmacy, and they work very closely and very well respected by the Board of Pharmacy. But what's nice about SARF in Pennsylvania, and New Jersey has a corresponding program as well, is that the licensee can speak freely and openly and get the treatment that he or she needs without feeling like they're telling the Board of Pharmacy. Now, there is a contract involved, and there's usually a certain period of time that the pharmacist must engage with SARF or the corresponding agency in your state. This includes pharmacy students as well as pharmacists. They're looking for early identification, intervention, treatment, monitoring, trying to get to the root cause of the problem or the triggers so that a program can be developed so that if those triggers are hit, then there are different outlets which do not include impacting patients or the person themselves. And again, I want to just state at the bottom of the slide there, it says not a state organization, not part of the Board of Pharmacy, but they are funded by the Board of Pharmacy. When a licensee contracts with an organization like SARF, they can avoid disciplinary action because it's the voluntary recovery program. At a later point, it may be a mandatory program where if you don't enter SARF, then you will not be able to practice. There'll be a disciplinary action whether you enter SARF or you don't enter SARF. If you are just in the voluntary recovery program, then there's no disciplinary action. So I always try to explain to licensees that it's route 1 or 2. 1, we can avoid disciplinary action if you go involuntarily. If it's a mandatory entrance, then we're looking at disciplinary action no matter what happens. The Board of Pharmacy will look at the SARF agreement and adherence to that program very highly, which is why sometimes you can see, even in egregious situations, the Board of Pharmacy will take the SARF program into consideration. Members of that organization will testify at hearings to help. From a criminal perspective, it's always nice to have that SARF program laid out for a judge or a prosecutor to understand that the licensee, even though they may have been stealing medication from the pharmacy, they've entered themselves into a treatment program. So an employer often will have a policy to contact the Board of Pharmacy. If you don't do it voluntarily, they're going to do it. Again, the Board of Pharmacy may send the case to the Attorney General's unit for criminal interpretation. That's not an always absolute, but it's something that we need to consider. And again, this program is designed at looking at all the possibilities when there's an issue and not just looking through tunnel vision. The key to this case is to avoid a controlled substance conviction or admission, guilty plea. In Pennsylvania, it's a 5-year automatic license suspension for a misdemeanor. For a felony, it's a 10-year automatic license suspension. So there's nothing I can do as an attorney to argue on a licensee's behalf. It's in the statute that if it's a controlled substance conviction, then it's 5 years for misdemeanor, 10 years for felony. If we can get that charge changed to retail theft, then we've avoided the controlled substance. We still have criminal issues, but we may, in the end, be looking at probation with the license, a 1, 2, 3 year suspension with the license, and not a 5 or a 10 year. So we want to resolve the issue if possible to avoid that controlled substance conviction or guilty plea. So therefore, we're going to recap the Board of Pharmacy penalties. A pharmacist could be cleared if it's really outlandish complaint. The Board of Pharmacy can send a letter and said, we reviewed the situation, we've looked at the facts, and we find no wrongdoing. The second thing is cleared with a reprimand. And that would be potentially in this last example where they said, we looked at the facts and we believe that a Board of Pharmacy regulation occurred, but we're not going to take further action. That, again, is not a disciplinary action. Obviously, if you're cleared outright, that's not a disciplinary action. As we move down into the red slide, the red statements on the slide, these are going to be disciplinary actions. And for some people, that can obviously impact your ability to get employed, and that in and of itself can have a huge detrimental effect to your license and ability to work as a pharmacist. So let's run through those very quickly. A reprimand with disciplinary action. So you could get that same letter as above and say, we believe that something happened and we are offering you to resolve this with 5 credits in patient safety. That would be a disciplinary action, maybe a $50 fine. Okay. So even though that's relatively minor, and I can see pharmacists saying, I can do those 5 credits, I can pay that $50, it's no big deal, but that's going to stay with you. Now you can do a full-blown Board of Pharmacy consent agreement, and that's admitting that you did wrong. You are agreeing to terms such as a fine, license probation, additional CE credits. That again is a disciplinary action. And obviously you're going to be more aware of that. But the one above that, and also if there's missing CE credits, that's a disciplinary action. You need to take that into consideration. The next item is a license suspension. We've talked about that. Could range from 1 to 5 years, 7 years. The main thing about that is at the end of the suspension, you can petition your Board of Pharmacy to get your license back. If it's a license revocation, you're off the books. You can't get your license back. And I don't even think you're eligible to retake the NABPLEX to get your license back. That could be a requirement to get your license reinstated from a suspension. But if it's revoked, I think you're done. And finally, I just wanted to discuss briefly with you malpractice insurance. It's relatively inexpensive. And because your license means so much to you, I recommend malpractice insurance that covers Board of Pharmacy disciplinary actions. As we discussed, they'll pay for an attorney to represent you in front of the Board of Pharmacy for a lot of the matters that we've discussed here. You want to consider that the employers which may cover you for malpractice matters likely won't have this type of coverage. So if you work for a chain or a hospital and there's a complaint against your pharmacy license, you're going to be on your own. And lastly, you want to make sure that if you work for a smaller institution, and I'm just giving you an example as an independent pharmacy, a nursing home, maybe a really small hospital, you want to make sure that they not only have general liability insurance, and that's what I call slip and fall coverage, but they also have malpractice insurance. And you would be surprised at how many owners of businesses that I run into in healthcare that don't have malpractice insurance. They only have general liability insurance because their insurance agent is not considering the type of business they have. They're only considering that they have a business. So they want to make sure that they have both. And you, as an employee, you can also be held liable if there's an error, and your name could be associated with a lawsuit as well. So you want to make sure that they have both.